Yes, yes.
Please, please, Your Lordship. Also, it's item number 43.
43.
File our affidavit within this week, Lordship.
Within this week.
And for the petitioner.
Any objection?
No. There is a
Mr. Devi?
Yes, sir. Very good.
Kevin?
For this part heard, madam. It was last posted on 2/4 November.
Part heard.
Yes, sir.
Well,
I will. The function part of the a definition matter of I am saying for yes, sir. Hello.
Item number 5. The senior is unable to appear today because his father is admitted. Kindly please, so Monday is next.
mentioning, yeah. Well, from 11.
Sorry, 11.
11.
Let's mention this prejudicial for second
Admission.
readings are complete.
Huh?
Readings are complete. Admission. State on this.
11.
File an affidavit. I like to file a short reply. Madam. I think madam, it was 16 they are marching orders. 13. Okay.
Classification, my lord has directed to take instruction. Further, the letter issued by the FPSL 23rd of April.
You have received or no?
Yes, we have received it under process, my lord.
Done the process.
Yes, Lordship may dispose of this matter.
Lordship, no instruction to me. Whether that has been done, it was regarding appointment. Lordship.
Because we have to.
Lordship, all others, similarly selected persons all were absorbed. Lordship.
Yes,
And
because
this person remained. Lordship.
as per
And
the
no
request,
reason, Lordship, because of APSC's Lordship, certain clarifications were
When were the earlier persons?
Lordship, they were appointed on Lordship 11 to 2026, 11th February. 11th February, they will give an appointment.
Give an appointment.
Yes, this is
That
under
taking
process
effect.
manner. It's under process manner.
That's it. That's
Yes,
exactly
Lordship, the department is taking up this matter, Lord.
You take your time, but you give him appointment with respective effect.
The Lordship may kindly dispose of this matter.
How will this be?
Yes, sir. And pass an
Not
appointment.
discuss. Area.
Can you as one like others? Response could be done for the other.
Minor
Do whatever you do,
Yes,
I'm not
yes.
stopping you.
otherwise eligible.
It is no bit of saying.
But in our letter, the letter of the office kindly clearly mentioned that at this stage, because my not till now nothing has been found, my not, but inquiry is going on. That's why my not none is that there is a line by your office kindly see at this stage.
Drafted by some lawyer.
So that is my not allegation is very serious, my lord. Very serious.
Whatever it may be.
But that's why, my lord, because your lordship kindly see the last time.
Is it necessary to make it?
So that
clarify that tomorrow if there is some allegation, you know,
that,
open to you.
exactly, my lord. But that line is there, my lord. Your lordship kindly mention our letters, my lord.
Not necessary to make. Why unnecessarily you want these lines to be put in the order? Further complication. What is the meaning of until stage?
Because, my lord, in respect of others, my lord, inquiry is going on.
We are not stopping it, but your letter is very clear. Decided to withdraw its earlier decision.
Last time, my lord.
Giving in avail the appointment of only in respect of.
Yes.
Said it could not be substantiated till date. Later, if you find yes, there was falsification of documents,
my lord,
title to take action.
So the inquiry is going to take long. So very
take your time. But meanwhile, what is the person supposed to do?
So that's why, my lord, we cleared it right for time.
So if you have cleared it, they will have to appoint you.
So that is down from our side, no objection.
That is what we say.
Awesome.
Appeared.
Yes, not appeared, my lord. I have submitted my application, but the exam has not yet been conducted.
When is it likely?
My lord, that has not been fixed.
It proves the better.
No,
you
my
have submitted.
No, my lord.
Yes, I have submitted.
Your lordship kindly see, my lord. They have submitted, my lord. Yes, my notice is yet to be. They are going to file a petition because, my lord, your lordship kindly see they are allowed to fill up the form, my lord, subject to result of the petition, my lord. They are raised because, my lord, conversation of letter was already rejected by the government.
Then we'll issue.
My lord.
But
Similar method. Same.
And here I am 7, my lord. This is the phone number 7.
the person.
No, person will be the person. Much of it.
Yes, CGC. That is not a ground for password. Instructions.
Yes, lordship. I filed an affidavit. The matter in the next week, lordship. I will. In the meantime, I will file the affidavit, lordship. Required, lordship. No, the stay. Lordship, no notice is required. Already permission from the chief minister office was granted, lordship, and therefore, for the satisfaction before for your lordship, I will furnish all the documents along with an affidavit. No formal notice.
But an affidavit will entail filing rejoinder affidavit.
Yes.
Lordship, yes, lordship, I will file it in the next week, lordship.
File it will issue a notice making it returnable by 2 weeks.
Lordship also is the transfer order, lord. And he got the stay, lord.
All right, you file it. After 2 weeks on the request made by the council, state respondent.
So next week,
No,
lord.
next week. Okay, tell me the date.
This lordship 15th.
15th.
Yes.
Based on 15th on the request. That's an affidavit. File. Interim order passed earlier. If any, will come.
That is 89 lordship. The summary trial has been conducted by Kespool. Then after they have awarded payment under section 58 and also recovery of loss. Pendency shall not be a
Tendency to reputation.
not even dismissed. But not dismissed.
Huh?
Even for 1 year loss, I am not dismissed.
Tendency shall not be. Redress the given.
Can fund of getting correction of date of birth and violation of the judgment and order content case was filed also. And regarding that one, the relevant portion of the judgment, my lord, page number 70, my lord, paragraph 20. Kindly transfer this.
Challenge the inquiry.
Getting the inquiry report.
And I have assigned the expertise inquiry. And the consequential order. There are I have categorically stated. And regarding the
Inquiry
content of
conducted under what rules?
an expert inquiry report, my lord.
Inquiry is conducted under what rules?
Sorry, my lord, page number.
Discipline and appeal
Oh,
rules.
yes, under rule 8C, paragraph 70. Paragraph 17 of the judgment.
Paragraph 17 of
Paragraph 17 of the page number, your minor 69, my lord.
69.
69 of the judgment. From subsidiary rule 8C and from the above decision, it is found that it is found settled that the state has the authority and power to refix the date of birth of a government employee, even though a different date of birth was accepted by the government at the time of appointment, but such a decision can be taken only after an inquiry undertaken in conformity with the principles of natural justice and fair play. In the inquiry, the employee must have to be given a fair opportunity of meeting the case, and the principles of natural justice must have to be followed strictly, as the decision sought to be passed is likely to visit the employee with civil consequences. It is settled that an inquiry is to be conducted against any person with strict adherence to the statutory provisions and principles of natural justice. In such an inquiry, the employer should take steps at first to lead evidence and give an opportunity to the employee to examine the witnesses of the employee. On the thereafter, the employee is to be asked whether he wants.
Time for 1-4-8.
1.
1-4-8.
10. 10. It's the C Borba for 9. Yes, corner.
For last 9 years,
Issue notice on the interim prayer. That is the matter being stated. Tenth of June.
Problem.
We set aside the judgment of the division bench of the High Court and restore that of the learned judge.
You show us the judgment of the courted bench. Courted bench.
Yes, that lordship will find 56.
Direction.
Ultimately, first write our last page, then to calculate our penalty.
Yes, Mr. Patak.
Underwent terms of slide 6 and serial number 6 and 19. There, the amount due to them have been calculated. It is based for the next available is
Passed by the courted bench. Era 18.
para 18-year lottery perhaps may not be applicable to them because there is a issue of interest also there. That will only be because they have been pursuing those petitioners have been considering the matter.
Article 141, my lord.
No, this is not the judgment in them, your lordship. The
My lord,
concept of interest will only be applicable to people. If my learned friend is claiming interest, then I may be allowed to file an act.
The courted bench, no interest was levied.
So the issue of interest was finally decided by the Supreme Court in paragraph number 80. So which is what the case. And it was only made payable to the petitioners before the effect. So if my learned friend is paying for interest,
my lord, the argument is there. Entire line of petition goes the
so I am not saying that. I am saying if he is paying for interest, then the issue of interest has to be decided individually.
time, my lord.
There will be nothing left to decide. Your lordship.
Yes.
Right.
That's why they've even filed a review was also dismissed.
No, I not all laid down on the article. With respect to my
Where has the Supreme Court addressed the question of interest?
At para 18,
Para
Para 18.
page number 90,
94.
Huh?
94.
Page number 94.
94.
Para 18.
Okay.
Para 18. Page 94.
Yes.
We set aside the judgment of the judgment of the High Court and the attendance shall be entitled to around 30,000 and their pay for the month of March 2015 shall be determined in revised case, thus revised pay shall be reckoned for completing the pension payable. The areas of pay and pension shall be paid in the revised pension shall be common from February 2020. The areas of pay interest at the rate of 8%, 6% for this past year. The above directions are not complied with and in the event of liability arising for non-payment of interest as directed herein above, the respondent shall pay the interest entitled to recover the same from the officer who caused the delay in payment.
Well, if they agree, then we have no difficulty in disposing it off. But if there is an objection,
Confident,
no, there's no question
There
of
is no question
consider.
of consideration.
Either we say that interest is payable or it is not payable. And then we'll have to hear them on the point of interest. If you want, they're not accepting the interest part.
how
We'll
can
have to hear them.
everything admitted?
The council understand something. Supreme Court has laid down a law. We are required to apply our minds, give an opportunity to the respondents. They are entitled to distinguish, for instance. But we'll have to hear them. If they agree that yes, these findings are correct, applicable, we have no difficulty in disposing it off. Only on the point of interest.
Only on the point of
Only on interest, not in respect of the other issues. That we can dispose it off. But if you want us to leave it to the department, you know the consequence. But renovated on 31, 31/3/2016. Claims of the writ petitioner are that of fee pension was claim of the petitioner. Entitlement due to the writ petitioner has not been by filing WPC 1607.
By
CA.
the company.
One 559 of 2025 by judgment and order dated 5. First, held that therein are entitled to pay revision as of 31 March revised scale, then such revised pay shall be reckoned for computing the pension payable. Directed to be paid. And the revised pension will commence from February. The rate of 6% for each year past. Any above direction for liability. Liability arising for non-payment of any be entitled to any motions onwards. Diary number 5623 of 2026. But date of the revised direction for payment of interest. Facts of the Sir KP Pathak understanding that while there is no dispute that the apex court has respect of action of the pension payable by direction of the court. Interest to the respect of facts and circumstances of the it's the concern of the respondent, present respondent, CL. That try to carry out the direction in terms of reckoning the same words. Finally, the pay for the month of March 2000 shall be determined. Revised pay scale and such revised pay scale shall be written for computing the pension payable. Area of pay pension shall be paid within a period of 6 months, and the revised pension will commence from February 2026. So far as the direction of interest is concerned, perusal of the judgment of the apex court, see that the interest is payable for each past year if the directions as laid down by the apex court are not complied with, and in the event of interest liability arising for non-payment of arrears within 6 months. This is how I understand it. Is there the kindly read the portion in the judgment respect of the interest.
The aliens of pay and pensions. Right? Past year. Directions are not complied with.
So areas will carry a rate of 6% if the above directions are not complied with.
Yeah. That is their way of looking at it, my lord.
No, that's not a way of looking at it. We are just reading whatever is there in the order.
Yes.
And if there is a further delay, then this interest amount will be recovered from the hearing officer.
It starts from 4.
Because the judgment was rendered in December 25.
Yes.
And the period is to commence on February 26.
Yes.
So there can't be an imposition of interest with effect from the date of the judgment. It is only in the event that these directions are not carried out, levy of 6% interest.
After the comma, my lord, what will be the comma? not complied with, the event of interest liability.
That's right. So in the event of interest liability arising for non-payment of arrears within 6 months.
Not paid, then other interest.
No. Further.
Paid. Other interest.
No further interest accrues. Read the judgment. There is no reference of further interest.
The area shall carry interest at the rate of.
Right, we right that in the event the direction is contained, present order are not carried out within a period of 6 months from the date of the order. Writ petitioners will be entitled. The respondent will be required to pay an interest at the rate of 6% for each past year.
Deeply.
Time of the
MS K1 for APGCL, AEGCL. What the matter? There are two writ petitions.
Yes, in final item number 9, the petitioner both were holding the post of Assistant General Manager APDC. But in item
Dates are similar.
everything is same, only place of post.
Yeah, item 9.
Assistant General Manager,
Manager and
posted at PCB. Part one.
item 10.
Gauhati listed as deep development.
Wait, these are lordships. Am I audible, lordships?
Wondering what are the flights from Delhi not operating to Gauhati?
Pardon, lordships?
Flights from Delhi not operational to Gauhati?
It
Mr.
was
Sinha
operational,
doesn't want to here in Gauhati.
No, it was operational, but it is my personal difficulty. I couldn't come. I'm extremely sorry for addressing lordships through VC.
Sorry. You don't have to be
It would have
sorry
been a
for
pleasure to
VC.
appear
We are
physically.
giving you the facility.
Yes, lordship.
Yes.
Now, lordships, I'm appearing in these two matters, item 10 and 11.
Yes.
The petitioners before your lordships basically are grade 4 employees. The first petition pertains to employees of Dibrugarh and the second petition pertains to employees of Goalpara. Now, essentially, if lordship will see our prayer, if lordship will take up the petition, Nitu Gogoi, and kindly have a look at the relief that we are seeking at page 29.
Yes.
In fact, if I may briefly put it before lordship takes to the prayer, these were employees who were earlier working in the health department. Their services were terminated. They challenged the termination before the single judge. The single judge upheld their termination. Now, after that, these employees, due to various reasons, particularly financial, could not go up in appeal. But their colleagues went up in appeal. In appeal, the single judge judgment has now been set aside, and the persons have been directed to be reinstated. Pursuant thereto, since we were similarly situated, we filed a representation before the department seeking parity and that the benefit of the writ appeal judgment may also be extended to us. Since nothing has happened at the authority level, we are before your lordships. Now, lordships have already handled a matter of this nature and have passed an order, if I may straight away take lordships to that. This is the gist of the case. It is admitted that the writ appeal judgment has now set aside the termination orders and the whole termination process has been said to be illegal. So all that we wanted was that the benefit of the writ appeal judgment be also extended to us. We are not fence sitters. We had assailed the decision of the state, but up till the single judge's level, we did not take it up to appeal. That's an admitted position. Now, if lordship,
Yes.
lordships will, pardon lordships?
Yes, please. Carry on.
Yeah. So if Lordship will kindly have a look at the prayer at page 29.
Yes.
Nitu Gogoi, if I may put it, a declaration to the effect that inaction on part of these respondents in not extending the benefit of the judgment and order dated so and so in writ appeal 429 of 2023 to the petitioners in spite of them being identical and or similar to the appellants in writ appeal 429 of 2023 is bad in law. This is essentially what the relief we are seeking. Now, if Lordship will see the judgment passed by the division bench, is certainly not a judgment in personam. It's a judgment in rem.
Yes.
And the next prayer we are seeking is a writ in the nature of mandamus and or any other appropriate writ or direction
What is your
of like
present
nature.
position? You were employed and you have been terminated.
We were terminated. We, along with others, challenged that action before this learned single judge. The learned single judge upheld the termination, against which some of us, not us, our
You did
colleagues
not
went up in
prefer an
appeal.
appeal. You did not prefer
We
an
could not
appeal.
prefer an appeal. Yes.
All right. Then why?
We
Then
did
what
not.
happened?
Then in the appeal, the termination has been set aside.
Right.
The whole process has been set aside by the division bench saying that it's not sustainable in law. And the petitioner and the persons were directed to be reinstated in service. If I may just put that operative part of the division bench judgment.
Then why did you not prefer the appeal?
Pardon, Lordships?
Why did you not prefer the appeal against the judgment passed by the?
Yes. We could not, Lordship. We have explained it in our writ petition at paragraph 41 that we were fourth grade employees. We had no financial resources, and it was under several personal and financial issues that we could not file an appeal. But we are not fence sitters, certainly, because Lordship, we had approached the court at one instance. Fence sitters would be those who acquiesce to the government action and have not challenged it at all. That is what the law says. So today, when the writ appeal judgment is there before us, it is service law would say that the same benefit should also be extended to us. If Lordship will see the directions of the division bench, if I may just place those directions, if Lordship will kindly come to page para 91 at page 359 of the division bench judgment.
5-1.
Page 359 of the division bench judgment, please have a look at the operative directions. And if this Lordship at page 359, Lordships?
Yes. Paragraph?
Paragraph 91, the last line of that page.
Yes.
I will read from there, Lordships.
Yes.
To summarize, the constitutional position that thus emerges is clear and admits of little ambiguity. Where appointments to public posts are made pursuant to public advertisements and the recruitment process initiated by the state against existing vacancies, and the appointees have served for a long and uninterrupted periods without any allegation of fraud or misrepresentation, such appointments cannot be treated as nullities merely on account of administrative or procedural lapses attributable to the employer. After the extraction of a prolonged service, the state is constitutionally restrained from undoing its own acts to the grave detriment of the employees situated at the lowest rank of service, more particularly when there is no allegation of fraud or manipulation and admittedly appointments were made after a selection process. Next one. For the aforesaid reasons, we are unable to sustain the action of the state government and the judgment of the learned single judge. The appeals are accordingly allowed. The common judgment and order dated so-and-so passed by the learned single judge is interfered with. The termination order issued against the appellants are quashed. The appellants shall be reinstated in service with continuity of service for all notional purposes, including seniority and pensionary benefits as per rules. However, balancing the equities and bearing in mind the public exchequer, the appellant shall not be entitled to back wages for the interregnum period. Now, these directions would also take into sweep all people who were terminated by this action. And this is exactly what Lordships have held when Lordships have recently passed an order in Akid Hussain. Lordship's own order. in Akid Hussain. If my colleague can pass on that order, except the only difference before lordships I take is that here in this case, the challenge to the termination orders were pending before the single judge. And then the writ appeal judgment came in. And therefore, lordships at para 6 onwards, if lordship will see from para 6 onwards, the learned, if I may place from para 6 onwards, lordships, the learned counsel for the parties submits that this writ petition stands covered by the judgment and order dated 30/1/2026 passed in writ appeal so and so. In the said writ appeal, the division bench allowed the appeal and WPC 1931/2020 and other connected petitions why judgment dated so and so stood interfered with the termination orders issued against the appellants are quashed. The
This
writ
is a
appeal was
consent
disposed.
order. This is a consent order.
In the sense, lordships, well, if since the parties agreed, because that is correct. That is the correct position.
If the respondents don't object, we have no difficulty. Yes. You say it is covered?
Lordship, we have to append my instructions.
What instructions are there? The judgment is there, pleadings are there. You read it and tell us.
Yes, sir. So I understand the way you've been put forward, but I still would need to properly go to the channel to find out whether it is covered. But no, whether the same benefits will apply to the petition.
When can you get it?
So give me 1 week's time.
1 week. We are only asking you because in the order which is placed before us, it is also the health department, isn't it?
Yes, sir.
Is Akid
Okay,
Hussain,
yes.
Mr. Goswami?
Yes, lordship, and same post. The Akid Hussain was also working in the same post. He
Yeah,
has
you
also
did not
been
object.
terminated by the same procedure.
Yes, sir. We did not object with that.
Same post, same procedure. Except that his writ petition was not disposed of, our writ petition was dismissed. That is the only difference.
We'll have it on next Wednesday. Let him get his
Yes.
instructions.
Lordship.
Mr. Goswami,
Lordship.
he says he wants some instructions. We'll have it on 13th.
Lordship, very well.
Third, Mr. M. Goswami, the senior counsel, has addressed this court in the virtual mode, assisted by Mr. R. Sinha, Mr. M. Guya, the standing counsel here. Petitioners, they're serving as what? Grade 4.
4 lordships.
Grade 4 employees in under the health department.
Which department? Dibrugarh and Gwalpara.
The districts of Dibrugarh and Gwalpara, after rendering years of service, terminated. Their claims before a coordinate bench stood dismissed. But no appeal was preferred by the writ petitioners. However, other similarly situated persons filed an appeal. The writ appeal number 428 of 2020 and other connected 3001/26. The appeals were allowed and terminations were set aside. Counsel to the stating that this is the judgment rendered by the appellate court, the judgment in rep, and is equally applicable. Accepted the judgment insofar as the writ petitions are concerned. Writ petitioners are concerned. There is one issue that you have not addressed.
Lordships.
See, there is a judgment already against you.
Yes, lordships.
Don't you think that you should go and file an appeal, reversing with an attempt to reverse this judgment? Because the judgment is a judicial decision operating against you.
Lordship, I appreciate what Lordship is right. I'll definitely examine that issue, but fact remains that a single judge's judgment has been set aside.
So the
So we
judgment
have
will
to
be set
examine
aside
whether it is set aside.
only in respect of those appellants.
It cannot be, Lordships. You cannot be that with respect to the appellant, the single
Was
judge's
it,
judgment is wrong.
was it, no, no, was it you had preferred a writ petition before the court
Lordships.
in which the judgment was rendered against you.
Against common judgment.
Now, is it a common judgment?
It's a common judgment.
It's a common judgment.
It's a common judgment, Lordships.
But nevertheless, you examine this issue because
I will definitely address that, Lordships.
because the question of the judgment operating against you, because you were not before the appellate court, whether it would be a relevant consideration. As agreed to by the
Lordships
parties.
will have then perhaps, if I'm not mistaken, then we have to see whether the judgment delivered by the division bench is a judgment in rem or a judgment in personam.
No, it's not about that. It's a question of whether the judgment interferes the learned single judge's judgment rendered in a writ petition filed by you.
Oh, this is happened.
For the record, that judgment remains.
With respect to us.
Yes.
Very
You
good.
want it on 13th or 15th?
Whenever it's convenient.
13th. All right, let it be on 13th. Although notices are not issued, extra copies be furnished to the studying council. To enable him to complete his instructions. Yes.
Much obliged.
Good for us.
There are two writ petitions.
Yes, sir.
Yes, Lordship, there are two writ petitions, one from one by Dibrugarh and one from Goalpara.
So 11 and 12.
Yes.
Both these writ petitions to be listed. On 13th.
Much obliged.
Same order in the other petition.
Yes. All right. Pass some order. Huh? Huh? You have a copy of that order? No. Third council for party should notice last one year. Sayu. It says Burwa. S. Sharma appears for respondent number 1. It says Burwa for respondent number 2, 3,
5.
5. The respondents are represented. No. Petitioner is the court. Respect of the parameters laid down by the apex court in judgment. Devrabrat Tiwari reported in the next day. Extra copies be furnished.
14 also have.
14 also same.
16 also.
16. 13, 14, 16.
Now, before your lordship, other chief dental surgeons are rendering their services in the rank of commandant in CRP. Lordship, they are facing hostile discrimination in terms of failure of respondents in exercising cadre review, which has resulted in severe stagnation and promotion. Lordship, initially, the petitioners were appointed in the rank of medical officer dentist the year 2000. Thereafter, initially there were the medical officers and the medical officer dentist, they belong to same cadre. In the year 2010, firstly, I would like to take you to the.
We'll have to issue notice today. I
Yes.
think for today, we'll only issue notice. Let them complete their pleading, examine the matter.
Similarly placed persons of identical department has approached Delhi High Court and the notice has been
We'll examine that. But you're Mr.
PK.
D.K. Bhuyan, Learned Counsel, M.S.S. Barwa, and CDC appears an exception officer. Finance area. They are serving as what?
They are serving as Chief Dental Surgeon SC,
Chief Dental Surgeon,
selection grade
selection grade,
in the rank of commander.
the rank of commander, vis-a-vis the other medical officers. You are alleging hostile discrimination with whom?
In terms, there, that is the cadre which has been streamlined in the year 2010.
What
And
is the name
medical-
of
the
what is the name of the cadre?
Dental surgeon cadre.
Dental surgeon.
And they have been separated from medical cadre, which was the cadre review was exercised in terms of medical officer in the year 2022.
All right. The hostile discrimination in respect of the medical officer. Yes.
So regarding non-correction of the date of superannuation in his appointment letter and subsequent non-releasing of his pensionary benefit. The petitioner is a grade 4 employee. He has been superannuated from his services, which is next, sir.
You want correction of date of birth?
No. My prayer is for consider my representation. Though after a thorough inquiry, my date of superannuation has been duly corrected by the officials of the Deputy Commissioner, and a various communication has been made before the Director of the Agriculture Department to correct the date of superannuation in my appointment letter for subsequently for purpose of the pensionary benefits. Since the Director has not been till date not been corrected by the date of superannuation in my appointment letter, my pensionary benefit has been withheld or not been released till date. Now, I have approached before the concerned authority for a number of occasions for requesting to release my pensionary benefit as well as the date of superannuation in my appointment letter. The Director, as per number 2, has not been taking any action in this superannuation. That is my crux of the matter. After the thorough inquiry, my date of birth and date of my superannuation will be corrected by the Deputy Commissioner Authority. The thorough inquiry made by the officials.
Learned Counsel and hardcore State Council.
I
Is
have
an exception.
one,
Notice
two,
on
and
behalf of
three.
all
No, my lord, 1, 2, and 3, my lord.
1, 2, and 3. Mr. H. Chakraborty appears to respond. 5 and 6. Since the respondents are represented. Brief extra copy. Take the
Patency shall not be a bar.
tendency of the writ.
Give them. Next, my lord.
File an appeal under the rules.
Yes, Lord.
You have filed an appeal.
Yes, Lord.
Where have you stated that?
In this same issue, another repetition is pending before the coordinate bench lordship, and in that matter, lordship issued notice. The page 46.
This is the education department.
Lordship.
Education department, civil bench 2 matter.
Lordship. Bench.
Why is it here? Think that the matter, the grievance of the petitioner, respect of school education. Sorry, Department of School Education. We will verify. And take steps to place the matter for the appropriate way.
But the impugn order is of 2006,
But family pension,
and then Dimahata has transferred.
third for council for parties issue notice, and I go 3 weeks.
One, two, three.
1, 2, 3.
But
Mr. R.N. Das for respondent number 4, 5, 6, 7 also. 5. 7. For respondent number 9. See if the respiration cannot.
Who was working as a forest utilization officer, retired from service on 31/10/2020. Now on 15/7/2024, there is an order from the senior accounts officer seeking to recover an excess payment of 1,61,340 rupees. Now we have challenged that order. Now at page 32, we had made a presentation. At page 32, that you would see the PCCF had given a letter that the period of excess payment was from 1/4/2017 to 31/10. Now, at para 4, the PCCF says that it is fixed as per ROP 17 and there is no excess payment. May I read para 4? As per ROP 2017, the pay scale of Deputy Conservator of Forest, Deputy Field Director, Tiger Project, rank of DCF, Senior Wildlife Warden, the rank of DCF is 30,000 to 1,10,000 grade pay, 14,500. Whereas the pay scale of Forest Utilization Officer is 16,900 ROP and closed. Now,
There are 8 lordship. Finally, as per the opinion of the office, there is no excess payment that has been made to Muhammad Mukesh Ali during his tenure as forest utilization of, hence the question of recovery does not arise. Now, lordship, again, the at page 30, the joint secretary thereafter at page 34 has joint secretary to the government of Assam Environment and Forest has said the same thing, that there is no excess payment. Now again, the accounts department are seeking clarification. Therefore, we apprehend that our 1,61,000 may be covered.
You are serving as what?
Forest utilization officer.
What grade is that?
Yes,
Mr.
Same
BP
as-
Bora, letter company. Mr. Gogoi, anything to submit?
Our stand is clear.
No recovery,
No excess payment.
no excess payment. Now, who is the accounts officer who has issued it?
What's the respondent number?
The senior accounts officer
In the accountant
office of the accountant general.
Who's for the accountant general, Mr. Talukdar? But the recovery will have to be made by the department only.
Yes.
Heard Mr. BP Bora. And Mr. D. Gogoi appearing for this department. Mr. D. Chakraborty appearing for
1 and 9.
respondents 1 and 9. Mr. R.K. Talukdar. 5 MSc Waterwood for respondent. Huh? 3 and 4. Number that respondents, more particularly the accountant general, seeking clarification for recovery of purported excess toil by the petitioner during his tenure. So, in this context, the counsel for the petitioner has referred to the application by the forest department. Submit that according to the forest department, there is no excess payment by the excess toil by the petitioner, and therefore there is no recovery necessary. However, in spite of these clarifications, the Office of the Accountant General further seeking clarification, so apprehending that some recovery may be made. Since the department has already clarified that there is no excess payment by the petitioner. The recovery that the department may subsequently consider recovery done without legal.
I think 10 also.
So probably for response.
1, 9 and 10. If you
Yes.
Lots of my lord, while working as an assistant engineer in R&D department, Inakandi Development Block, guy was arrested on 11/11/25. Connection with the case number BCB 25, my lord. And village demanding and accepting a bribe money of amounting to 7,000, my lord. Thereafter, my lord, lesson number 2 has issued an implement order dated 5/12/25 suspending the petitioner pending trial of the departmental proceeding as per provision of the 6(1) rule of Assam Discipline and Appeal Rule 64. With effect from the 11/11/20 and very date of arrest, my lord, the petitioner approached the Honorable Special Judge and granted bail on 12/12, my lord. Thereafter, my lord, this recommendation submitted before the authority, my lord, no reply, my lord. And no successor allowance, my lord.
Yes, get
6 months
instructions.
elapsed, my lord. So for successor allowance is concerned, my lord,
Subsistence allowance not received.
not married. It's my constitutional obligation, my lord, of the state, my lord.
Get instructions. Let them obtain instructions here, Mr. Ahmed. You're also questioning the suspension.
Yes, my lord.
Then we need to know. Service. Secretary. Yes, for one,
One,
two,
two, 4, 5.
4, 5.
Time for
Mr. A. Chakraborty for response.
All is settled, my lordship. You are just facing the lordship memo.
8th of June. 8th of June. This can hurt secret.
Post 94 and 95 sound.
94, 95. Hurt counsel for parties. Same order, please 94, 95. Mr. A.K. Dotto for the learned citizens of the state. 94, 95. Yes. But are you entitled to make a claim? Under what provision you want this? You show us a provision. What natural justice? You are not qualified. You are asking for relaxation of qualification. What provision? Show us some rules. Show us some indication. You have come before the court asking for an order. That you must be able to carve out your right. That yes, under this particular provision, I am entitled to be considered or given that benefit. Direction, even that direction is also will be misplaced because there is no. Third counsel for parties, petitioners are reviewed by petitioners are marks in less than 50% marks. They are presently seeking employment presently seeking submit their applications in terms of an advertisement dated 19 to 2026 issued by the respondent department for filling up 1508 numbers of posts, including Gramin Rozgar Sahayak, computer assistants, Gram Panchayat coordinators under MGNREGA, and PMAG Finance Commission. Stop, however, the percentage. The requirement is the percentage requirement of having 50%, minimum 50%. Where is the advertisement?
43. Yeah, nice.
I don't think we can pass an order. The advertisement is very clear. Accommodation will open the floodgate for all.
Now, this is still what they were earlier appointed.
Where is that provision under the advertisement?
Well, there's no provision. But
Then it will send a wrong precedent.
they were appointed earlier. I have benefit earlier order.
No, no. What happened to their earlier appointment?
Earlier appointment, my lord, those court state they would have got their.
But you abandoned that. Writ petitions came to be dismissed.
No, my lord, and
Maybe.
for non-prosecution.
That's right. But it will not be proper to issue such orders.
There is that they want to participate.
You show us any provision that the government is can give relaxation pursuant to the advertisement. Some provision, some precedent. Otherwise,
There is no provision, my lord.
of course, that is what the advertisement says. What for is the advertisement issue? What for is the advertisement issued? To lay down the criteria. We are entitled to file application, but we cannot issue. It will be wrong. Even if on sympathetic consideration, you must fall within the parameters. Why sympathy must be given to you and not to others? You were earlier appointed, that proceeding has come to an end. That's your fault. Dismiss today. What do you want to withdraw? Not after 1 week, Friday. Next on Friday on the request made by the council. Friday. We are not dismissing it today because we are giving you an option to think about it if you want. No, Friday. Maybe your problem, but we'll have it on Friday. Can't be helped. Or at 2 p.m. Friday.
My petition is aggrieved by 2 orders passed by the CRPF authorities. Initially, my lords, the petitioner is a constable. He suffered from alcohol dependency syndrome. He was put in shape 5, temporary for shape 3 for 20, at annexure 1, page 21, shape 3, S3 for 24 months. Then, my lords, at annexure 2, page 24, he is brought that he is brought before the Department Rehabilitation Board. But the Department Rehabilitation Board sends me to Medical Invalidation Board, which is not his job. Department Rehabilitation job is board's job is to seek rehabilitate me in some other jobs without without gun or without firearms. But they, what you will see at page 24, it sends me for invalidation. And also recommends me to go to Snehalaya. In between, he may be sent to Snehalaya for improving his health. And then, my lords, I get treated at page 25, Annexure 3. Lords, you will see I have been categorized as S2. T24 means, my lords, for the period of 24 months. Fit for duty without firearms. And then, my lords, I get treated at Snehalaya. I got reported there. I get reported there at page 26, my lords. I've been again at bottom portion, my lords. I am upgraded to S2. Page 27 also, my lord, they say, my lord, in case you have a, if you to defer, you can go for a review medical board. My lord, but by the communication at page 30. Page 30, my lord reads, it is informed that the individual has been placed in medical category
yeah.
S5. But it's never S5, it's S3, and that also it was temporary, assuming it was correct. But in the meantime, they disregard these other reports, whereas, my lord, I have been upgraded to S2. And in the meantime, this by this communication, my lords, at page 30, and
Yes.
my lords, they are now gathering the medical invalidation board. Whereas a review has had to be conducted because I was upgraded, I was improving, my lord, because that S3 or S2 was permanent, it was temporary for a specific period. My grievance is, my lord, if they send me to the medical invalidation board, that
For
too also,
today, we'll have to issue notice.
my lord, status quo we maintain, my lord, because the board has assembled.
Maybe,
orders.
but let them examine you properly.
No, my lords, they cannot examine me, my lords, because they have to go for first a review. Then only they can.
What do you say, Mr. Bedi?
This is notice made.
When status quo, they will send me to this board, and this board will invalidate me.
But board will have to constitute and examine you first.
No, but before this, that stage comes. my lords.
We'll examine that. We're not saying that we are closing your petition. The status quo will,
Till lordship examines,
the whole
my lord,
process, my
my
lord.
lord.
the entire process will come to a standstill.
No, my lord, in a short time, they will come and clarification. If that be the case,
Heard Mr. D. Goyal and accountant. That without resorting to medical review is contemplated under the rules, the petitioner is likely to be placed before the
MIB, medical invalidation.
medical
Invalidation board.
invalidation board and will thereafter be invalidated out of the service. Such apprehension, the petitioner is before this court. Since the respondents are represented, then the petitioner is placed before the medical invalidation final order aspect of
The out of station manner, kindly manner may be on 11 and 12, not the only manner. It may cause injury to other party manner.
12.
11 or 12 manner.
12.
Obliged.
This is the item number
21. Obliged.
Yes.
The pertains to pension and higher wages. As we are getting pension, but focus notice was issued as to why the pension is. They are challenging the focus notice. That 420.
The other matters have already been, when are they fixed?
14th of
connect it to the other matter. Preparing for, yeah. Opinion fund.
Authorized page 420.
For IOC. On 14th of May, being WPC number.
Five eight two three.
WPC 5823 of 25.
25.
Another connected restriction. And insofar as where is the show cause?
Page 220.
Huh?
420. Correct, sir. Oh.
The petitioners are agreed by the show cause notice dated 26. Cancel the higher pension and the pension on higher wages in revision to normal pension. Respect of the petitioner. The next date fixed for the action the adjustments to the impugned. So, respondents may complete their pleadings and find necessary affidavit. 14th May.
Of the Gauhati Medical College. Agreed by the notice issued by the local committee. What's happened in the matter, the respondent number 7, she had tried for an opening of the Department of Clinical Psychology, which ultimately was opened in 2023. Subsequently, the department has been closed by the government of Assam, and she blames me for that. And since then, my lord, she has been lodging complaints against me. It started with a complaint dated 6th of February before the Honorable CM. Committee has been constituted. I have replied. Then she approached the internal committee under the POSH Act, my lord. I was preparing my reply. Then the chairman informed me that she has withdrawn it, and then with the liberty to move the LCC. Now, if I may draw your lordship's attention to the act, my lord. It's handing over.
Prevention of sexual harassment.
I have a printout, my lord.
Yes, yes. So, add a copy.
I may take your lordship to section 9, my lord.
This is sexual harassment.
Yes,
and
that
women, yes, yes.
Starts with B actually. Sexual harassment. Yes.
Yes, okay. Section?
Section 9, madam. Any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal committee if so constituted. Pausing here for a moment, madam. In the GMCS, there is an internal committee. Or the local committee in case it is not so constituted. So one can approach the local committee only when the IC is not constituted. Then if your lordship reads further, madam, within a period of 3 months from the date of incident, and in case of a series of incidents within a period of 3 months from the date of last incident. Then lordship reads the second proviso.
2026 issued to the petitioner by the chairperson, local committee, POSH Act, Kamrup Metro, directing the petitioner to appear before the committee on 8/5/26 at 2 p.m. Earlier, private respondent number 7 lodged a complaint before the ICC, which was constituted, and subsequently, state complaint which was communicated to the petitioner by the chairman of the ICC GMCH on 11/3/20. Thereafter, it was lodged before the bill committee, pursuant to which the impugn notice petitioner submits by referring to the sexual harassment nine. Once the internal committee is constituted, and the complaint is required to be noted with the state committee. It's further submitted that the limitation for loading a complaint with the internal committee 3 months from the date of the incident, with an additional 3 months subsequent by the committee. Submitted that the allegations pertain to the months of
As per the complaint, it is from 22 November 22 to July 2020.
November 22 to July
5.
2025.
As per the complaint, madam, because
As
that,
per the
as
complaint.
per the
Therefore, he submitted that said complaint is time barred under section 9 and therefore not have been taken up for a fresh inquiry by the LCC by issuing notice as impugned in the present petition. Counsel for the petition rendered in civil appeal number SLP number 1793 of 2026. Sorry, 25. Dated September 12, 2025. Passed in Vanita Patnaik versus Nirmal Gandhi Chakrabarti. Referring to the said judgment, that the apex court has held that complaint of sexual harassment is mandatorily required to be filed within a period of 3 months from the date and within a maximum period of 6 months from the date of last incident of the harassment so alleged. He therefore submits that as per the complaint, the incidents had occurred well before 6 months. Therefore, the complaint is time barred. He therefore submits that before directing the petitioner to appeal, authorities of the examined mandatory limitation specified or mandated in the Act. So he submitted that matter be decided and during pendency, the impugned proceedings be stayed. Well, Mr. D.P. Bora, the council as well as submit that the instructions are not complete, they will like instruction. Prayer for entry will be considered on the next returnable day after return of service on respondent 6 and 7. Meanwhile, till the next date fixed, the stated so and so shall remain stable.
It's 29th of May.
29th of May.
Pertaining to recovery of each and hardship belongs to
Page.
last page.
The rest committee, the LCCC for the respondents. Extra copy.
I think it's enough.
Requires some hearing.
Yes, fine. For 2026, I filed the.
What is the, this for appointment of arbitrator? What is the objection?
My lord, because arbiter and tribunal has been constituted, my lord, is not for appointment or arbiter. It is for
Substitution.
Not, my lord, it is not the case of substitution. It's the case of long pendency of arbitration proceedings.
No.
And when there is,
Hear it.
and when, my lord, there is a long pendency, then this honorable court has jurisdiction to appoint the independent arbiter.
List this matter on 2nd. Item will be made to hear and dispose of the matter on the next. Yes. Complied.
No, my lord.
Fine.
Just find one detail appeal before the sentence, my lord. There is a delay, the notice has some delay, my lord. And in the main case, there are, my lord, all total 148 petitioners. Out of 161, we have complied with 10 matters, 61 petitioners. And regarding that remaining petitioner, they are not complied with regarding the petitioner because of some technical part. That's why we have filed our appeal before the sentence also.
Technical.
They're not only technical delays, they did not possess some. Here we have
When is the appeal?
holding the post of.
When is the appeal listed?
Appeal was listed on 7/4/2026. Last it was listed, and on the delay confirmation that notice has already been.
When is it next fixed?
There is some returnable on 3/8/2020.
3/8.
This is the last one. No, manufacturers, after review, after appeal, we prefer the review, and after review, we have terminated from the appeal. That is 1535 just because from the original date appeal, manufacturer. Sorry, this petition, not from the written.
Of an appeal being preferred, we'll have to defer it. That's the.
Comply with the order subject also.
What is the direction of the order? What is the direction?
Direction has been based on his judgment. Find the judgment has faced in A.
You are alleging willful disobedience in respect of which directions?
In respect of page 58.
58.
48.
48. In view of the matter, the appeal is preferred. The appeal is preferred against this judgment. Direct compliance for outcome of the appeal not be a proper course of action. You are entitled to agitate the matter. You are a party arrayed in the appeal.
Yes.
Yes,
Yes,
my lord. Taken the time, my lord.
You raise all these arguments before the court. What to do?
We have filed a condemnation petition and
Third, counsel for parties have submitted that an appeal has been preferred before. And then, against the judge order taken. Six 603 of 2014. Status of the bar is submitted by the respondents that pending the fix is 38.
38, madam.
Where I consider the fact that you are entitled to appear and raise your objection.
Not even numbered, but in front of delay, because
Dismiss.
Yes, it was dismissed, my lord, on last 29/4/2026, my lord.
Then comply.
Yes, my lord, we have already communicated to the department, and I am seeking an accommodation of 4 weeks, my lord, to just carry out the process, my lord, because we have to restart it again, my lord. In between, because of filing of the appeal, my lord, the authorities were under the impression, my lord, that
It is submitted by the counsel to the petitioner that the appeal preferred by the respondent. Yes, the order dated 5/10/20.
my lord,
7131 of 21. My order dated
my lord, 29/4/2026.
29.
First in IA civil number
First
seven
IA civil number
719 of 2020.
That will be the matter. The respondents are permitted this time to comply with the directions contained in the order. Then from
So deeply obliged.
the
No other way,
respondents
my lord. There is no other way.
are permitted to submit the compliance report the next day.
I'm so obliged.
Please, Lordship, Lordship, my installation are the courses, Lordship, any possible for time.
Rejected. Submitted. Submitted by the council to the petition that DWP by the state against the judgment and order dated 25/6/2024, passed in WPC 367 of 2020. Compliance of which, for non-compliance of which the present contempt case has been filed, is to dismissed by the division bench by order dated 7/4/2026. Permitted this time to comply with the directions contained in the order dated 25/6/2024, passed in WPC 67. Time there is Mr. Dr. Tony for respondent number 6.
Our company on behalf of them.
So appears on behalf enough for respondent.
1, 2,
Payment order has been issued, Lord. Paragraph 2 of the pension payment order, it is already clarified. If the pensioner wishes
To
to
an
draw,
authorized
Yes.
agent.
Authorized.
There already.
It's there, my lord, I'm not saying that.
Then
But the only thing quite likely for the delay and all.
there in the order, have you seen a copy of this order?
I've seen, but
There are two, it is clear. What steps you are to take? Third count, by the learned counsel. Are you referring to which respondent?
Lordship, I was not made party, Lordship, but in terms of order, Lordship, I was directed to
Okay. The counsel for the accountant general, Mr. Chalu, was requested to assist the court by early past price report. The pension payment order number 9045113136 issued on 5th of May. directions contained in
One is creativity payment. One is creativity also.
next page,
Yes, next.
same petition. Five one 626.
This method also we have already preserved on appeal law. During the hearing of the appeal on the last date law, the council has they are not willing the contempt.
Yes. Submitted that
His failure, Mr. Vijay Kaur appeared on that. Okay, number 117202.
117 stated that
Apply.
both contempt petition,
Same against the same.
same order.
I have filed an application as well. Personal when personal serve the notice, but he died to the notice. Like the
Fine. Fine, you have it not already. You file your rejoinder. Not necessary.
under full I
Corrected.
They must allow Lordship.
Respondents. Representing respondent 6. Taking steps.
I was at stage
Now you have to take a fresh step. File amended course title. Corrected me. File affidavit in next again after 3 days. Help.
Yes, sir.
You're appearing? Someone?
Father dies in harness. Hospital kindly care is ordered in the case for the father.
Payment not received. It's the new woman. Council help. For the time to complete instruction. Considering the claim. Respect of the new pension by the 11. Get your instructions. Yes. A more work.
For respondent number 7. This time may be allowed time for filing.
You are not allowed, you are not entitled for pension. Son.
Yes, sir. Son.
Of the second wife.
Second one.
Find your affidavit. Find your affidavit.
Yes, sir. This time may be allowed. Nothing.
First wife. interim has not been granted. Have you been receiving pension? You're receiving pension,
Still yet,
not receiving.
not received, still yet.
Are you processing the pension papers? Yes. They want some time to file affidavit.
Yes.
Counsel for the petitioner, respondent wants CC.
Yes.
Please for further time to complete. Has prays for further time to file their affidavit. Instructions and CC. They may after 4 weeks. Interim order passed early.
I have filed the affidavit, Lordship. Let it come up on Monday, Lordship.
The meantime, I'll file a form.
By Monday you can file.
Yes.
The P. Sharma and it submits that the affidavit has been filed during the course of the day. Order. By joint the affidavit. The affidavit filed. Or you will be able to file it. It's agreed to by both parties. Devin, the history in the meanwhile. We place out the affidavit filed by the respondent. Correct. Prayer for interest. Ready?
Yes. In this case, also on last occasion also, I was directed to take instruction from the SSC whether why his result was not. Yeah, I have received one letter from them on mail. Under process.
Yes or not declared?
Not declared, not his details, but he was found fit. This is not last time. I have submitted.
Doesn't disclose anything.
But the DSS has again he was re-examined as per the honorable of this court order. He was re-examined and he was found fit. And thereafter that was sent to the SSC for declaring the results, but that has not been declared. Also. That is under process. They have submitted. So the direction to some time get it.
You tell me how much time. expecting. That the employees of the Assam State Minor now thereafter the set of employees they have all taken 280 numbers. Out of that, absorbed in the irrigation department and left were given the benefit of the air. We belong to the category who are not absorbed, not given the benefit of voluntary retirement service, are now claiming the pensionary and the after retirement benefit. Yes.
Nothing close corporation. So I submit that they are not entitled for pension. Not entitled for any pension. I affidavit. Employees of the aspirant corporation and they were given VRS, all benefits. On the notification notice by which notice they were given the benefit of VRS.
We are not denying that this scheme would be a benefit. On the day of our voluntary file your affidavit.
Lot. I mean, it's also necessary, but
Are you for irrigation?
lot time for irrigation.
Want to file your affidavit?
Lot. Oblige.
In this case, we have received the paragraphs from Mr. We will file our affidavit now. 3 weeks time may be considered.
3 weeks. Fine.
I was challenging a transfer order, they're transferring out me to Karnataka, and I am from Manipur. I'm the only
same marking orders by 15.
No, Lordship, that on last occasion, though I made a submission,
Yes.
he is not covered because he is a ministerial staff. He is not covered.
My ground is that there's no male member out there. I'm from Imphal, and that the situation is
You're posted where?
I'm posted now in Gauhati, my lord. Being relieved to, I've been sent to Karnataka.
So where is your family?
Is Manipur, my lord, Imphal.
Then you are in Gauhati only. But
Otherwise, my lord, but I have completed the cooling off period also. I am
around that you are transferred out, no male member, etc. Out of the house.
From Gauhati, Manipur, it can be managed, but from Karnataka, my lord, I cannot take my family there, my lord. There's no male member. I have a mother. And page 53, my lord,
that's a service condition.
I understand, my lord, but given the conditions of Manipur, it is also fading up now. And page 53, my lord, my wife is undergoing treatment at the psychiatry. Doctor has categorically said that she needs my care. And I've been looking after the family of my brother also who died in Corona. My lord. 3 children are there. That's about, my lord, the standing order at page para 16, my lord. Stand at page 30, Lord, you will find there is also that they can deviate from this. If the DG has the power to given the circumstances of Manipur, because I have also completed the cooling off period. Give me any notice. I agree to that. To that extent, I agree. But going to Karnataka, my lord,
Out of Lordship, 31 years of service, he was at Imphal within Manipur for 20 years and within Assam for 6.8 years. So about it will be around 26, 27 years he has within Northeast zone. He has never been the South. Now Lordship, he has filed and now everything is done through software. It is called CENTOS. It is Lordship known as System for Annual Transfer over Software. Now everything is, even participation is not there. Everything is done through software. Lordship, can you see the preference he is given? Page 72. Nowhere he has stated Imphal, Lordship.
no, my lord, there is no option of.
Kindly see the Lordship, it is Ranchi, Bihar, then Director General Office, then again Ranchi, Jammu Kashmir, or RAF, then Haryana, then Rajasthan.
Right.
No,
Raipur.
Raipur, Lordship. Nowhere is stated about it.
Do you consider his preferences? Why?
No, Lordship, as I
Even,
told
my lord,
Lordship,
assuming, my lord, I am wrong, but they should have considered my preferences also. But then they are sending me to Karnataka, which is not even with their choices also. And that part, my lord, is
Lordship,
choices
one
of
instruction everything done is nowadays with software.
I understand everything, but we have asked him
And
to
he has
give
never been in the
choices.
southern zone. Now, Lordship, we have to rotate Lordship person.
Saying it's a prime responsibility for the his preference.
Lordship. But everything, the Lordship, may kindly see the page 34 also, Lordship. 6A.
You don't want to send him to Manipur, right?
6A, Lordship, may kindly see 6A. Page 34, Lordship. Every official personnel will be able to give preferences twice in various eligible elite officers. The maximum number of preferences which can be given in various categories will be decided by directorate. Preferences are to be filled up very carefully, keeping of the vacancies and score. Filling up the preference is not a guarantee for posting to preferred unit establishment. So it doesn't come with a guarantee, Lordship.
But my lord, if 6 is
And no official personnel can be claimed for any particular post or location. We have post person on the administrative exigency and operational requirement.
my lord, we are dealing with the has to be a human aspect also. Because 6 says through software. How can a software understand human hardship, my lord? Because in the rejection order also there is no reason. Simple to rejected. And I write the DG also.
Considering all the terms of the preference.
That's right. But not stay on. Find a fresh representation.
Huh?
You'll find a fresh representation.
What happened?
a time bound notice.
I have taken instructions, those that preference areas, I wanted to go to Manipur also, but the system is not showing Manipur.
Just because he has never served outside the division. He has served there for 28,
I understand
20 years.
the pros and cons of this kind of service, but
He served there for 20 years.
human approach should be also there. I have a mother of 82
Within
years.
Northeast US for 25 years.
How did you allow him to stay for CentOS?
Earlier there was no CentOS was perhaps applicable recently, not 3-4 years ago.
CentOS is not expected to understand human hardship and software. But every order, either quasi or judicial, anything order has to be bought by reason.
Like you, everyone will have hardships. Nobody wants to stay away from the family.
Yes, madam, that's a different thing. But
you show us under the standing rules that your case can be considered.
30. Three minutes. I have completed 6.8, 6 years, 8 months. 16 itself says there can be departure. Of period, madam. I was posted.
Where were you posted in your home state?
In home state, my lord, I was. I was in Manipur, my lord, till 2019. 2019. And 2019, I was brought to Gauhati.
Then
19 in Jorhat.
Jorhat, my lord, in Assam. Then, till today, I am serving in Assam.
22 he was posted to Gauhati.
It's 30 minutes. It's explicitly demonstrates my posting. Okay. 30. There's a chart. And I was in also pilot in Maharashtra. Nagatala. Number 3 minutes. I was in Maharashtra.
Once outside the region of Northeast. Otherwise, most of the time he is in Northeast. You have to balance the all India level lot.
transfer your representation was submitted where you got sent out.
My lords, I submitted 2 representations. My lord, to the DIG organization, that's page 17.
No, you come to page 37, clause 12.
Yes, my lord, through CentOS.
Then submitted.
Because CentOS also, my lord, you see.
See, you are a member of the All India Services, Armed Forces.
My lord.
One of the conditions is transfer.
My lord.
You are being transferred.
My lord.
There is a set of standing instructions. Show us under what title to not be transferred.
I understand everything, but even the situation of Manipur, and specifically from the area of Imphal, I have nobody to look after my family.
You bring your family to your place of posting.
But I cannot afford also, because my service is so category, my lord.
Can't help you.
Because at page 17, and Lordship will see, there's no reason also. Santos rejects my application.
But you have to apply for it.
My lord,
I think you are.
sometimes, my lord, what happened, my lord, because to apply to Santos, there's a timeline. I might have missed it. I missed the timeline, so I went further. And it was
Your grounds.
and wife is, my lord, suffering from psychiatric. At page 53. Kids, my lord, studying, my lord, at school. Taking everyone, my lord.
His paper says one of the daughters studying at Insukia Lordship.
Can't find any ground.
That apart, my lords, when they write it rejected, some reason has to be given. No, this is Santos, I understand.
What is the page 91? What has happened here? Page 91.
91, my lord, it has not been acceded to. Because they have
Rejected.
I don't know its fate, man. What happened?
What has happened to this?
Inspection activity. Monday, okay.
Eleven. Problem.
Any objection?
Yes, Lordship, as because pending of this, we have received instruction and that instruction already produced before this good court, Lordship. As per our instruction, pendency of this petition 3532 or result not published.
So
That
for
is
the
a-
item number 15 concern, my lord, I will go through all the orders. Order has been filed.
They are not saying stay order is.
Yes.
Because of the pendency of the writ petition. But in item number 49, you are challenging what?
I am not challenging anything, my lord. I have participated in the selection process, interview has been held, and thereafter Silas process, but no appointment has been made.
No
Therefore,
Yes.
I approach to declare the result, my lord.
for
And
post
in
of
50,
Anganwadi
what has
worker.
happened?
Light of the guidelines, my lord,
You are claiming the and the present petitioner
Like for press recruitment process.
recruit.
Yes,
Recruitment
Lordship.
process.
Both are Anganwadi worker, Lordship, for same Anganwadi center, Lordship. As because
But you have already called for the process of selection by way of anything
yes, Lordship.
have been identified.
Yes, Lordship.
And
But
only
some posts are by promoting Anganwadi helper to Anganwadi worker, and same Anganwadi center is involved. Both are from the same Anganwadi center.
they will have to then set of posts.
Yes. Yes. In item 50, petitioner seeks promotion from Anganwadi helper to Anganwadi worker, and for that same he was rejected. Petitioner was rejected as because as per our affidavit, he has not produced the all documents also. Therefore, she was rejected, and then she filed this writ petition. In the meantime, press recruitment process was carried on, and list was forwarded to the director office, but the directorate office not approved this as because pendency of this petition because if petitioner is eligible to promote the same post. Anganwadi worker is same for the same Anganwadi center. Therefore, this cannot be approved by the directorate. Then para
I have not submitted from on my cert. They're partially they are saying that my certificate so far. That word is not mentioned in here. Separate category.
But-
So my case will be taken up another day along with my affidavit. Have been filed today.
Anganwadi center is same. In petition 49,
We are asking you.
yes,
that
sir.
you have proceeded departmentally by advertising.
Yes, sir.
Process
Has
undertaken.
complete, sir.
Now, because some posts are to be filled up by promotion,
Yes.
why have you stopped?
As per my instruction, Lordship, respect to the subject cited above, I'd like to inform you that the name of the selected candidates for the post of Anganwadi workers of Salibhumi Kumargati Anganwadi Center has been forwarded to the Office of the Director of Women Child Development and Assam for approval. I would like to inform you that the result can be published only after the approval of the Office of the Director, Women and Child Development, Assam. A copy of the letter forwarded to the Office of the Director, Women and Child Development, Assam seeking approval has been enclosed with this letter. Moreover, I would like to inform you that the selection procedure for the above mentioned post is under subsidies due to complaint petition filed by one of the candidates in the Gauhati High Court case WPC 3532/25. Yes.
He's saying both are two separate categories. They are asking for promotion.
Yes.
And
And
you are proceeding the matter by way of an MP. Are you challenging the same post?
center is same.
How many vacancies are there?
Only one vacancy so far, Salivil Kumar Anganwadi Center is concerned, my lord.
Only one.
Only.
Wherein I applied in the direct recruitment process and the procedure has been going on. And that post, my learned senior colleague has been taking on.
He is working as an Anganwadi helper.
Then why
in
are
that
you withholding the selection process?
as because same post both petitioners are claiming for it.
They are contradicting their views.
Yes, Lord.
This regard, my lord.
Is it the promotional post or directly?
That instruction not yet.
Post has been advertised, my lord, for direct recruitment. The advertisement.
Submit your fee. Okay. So June.
Okay.
Regularly coming up with some new and fresh regulations.
What is this IA for?
This IA,
IA for.
IA is because have hidden certain facts, and basically it was they had given in their affidavit that the tenure of two of their officers are retiring in April 26, whereas actually it is in April 27. Lordship, I would also a fresh development which has come. The question is whether we are seeking justice approaching the High Court is a crime. Why I say this is the respondent authorities in the interim has been indulging in retaliatory action, and it's on paper, harassment, forcing me to leave, and direct gender and regional discrimination. In spite of the matter being in court, Lordship, and under judicial scrutiny, they have issued intentionally and deliberately an illegal, malafide, and malicious arbitrary order dated 27th April, this 27th, which is gross violation of my basic principles of service law. May I submit this to the court?
Let us be dwell with the transfer matter. These may be a fresh cause of action. Might come of the
Lordship,
fresh petition. Never ending process.
I will respond. Just responding to what they have done. Lordship, this is the performance management report which is akin to an annual confidential report. Now, this PMR was for the period 1st April 25 to 31st March 26. During this period, I was working under the general manager.
How is it relevant to the transfer?
Lordship, it is relevant because they have, I draw your attention, the person who had initially said that girls should be working at home. That same person I'm being put under. That is number one.
It's a separate post.
No, that is already, it's there in my main petition. I'll draw your attention to para 8 at page 10. Page 8, Lordship, para 10, para 10, page 8.
Your prayers are all pertaining to the transfer order.
Yes, Lordship, but this is violation. They are forcing me to leave. Certain verbal things which are.
Where is the person?
Could have been okay. We are talking of the previous year. After I have submitted to the general manager, and Lordship, I'll draw your attention.
File complaint before the appropriate authority.
Lordship, we have already filed there, and we would like to bring this as an IA because
that all separate issue. You are now agreed by the transfer order.
We are agreed by the transfer order, and the transfer order is based on discrimination because there is malice involved. And now they are trying to put
all
me.
These have happened after the transfer order.
Lordship, this is now how they are harassing me. Daily, as a young girl of 28, daily I am being harassed. And they are just because I have filed the case. Lordship, when I feel that injustice, when the respondent authorities are not listening to me, where do I go if not to the court?
Yes, where are you posted now?
I'm at Namsai.
Namsai.
No.
Facing harassment in Namsai.
Lordship, that is what I'm saying.
Now?
This, Lordship, I am facing harassment because they are, besides verbal this thing, this is how they are doing. This is there on, and Lordship, if I were to refer to the policy guidelines, a copy of which Lordship I have just submitted. There, Lordship, at para 7, it is given that if the appraisee is working directly under the accepting authority, I was working under the accepting authority will assess the executive as the reporting officer, reviewing officer, and also as the accepting authority, unless a reporting officer is designated for the purpose. Now, I was working under him. My period is over. That day, the whole transfer order is based on malice in law, and this is the continuation of a series of harassment which is being done. It is a continuation. It is not 1, 2. It is a series of, it is a continuation. Despite Lordship, the intent, basically, if we look at the intent, there were others who were there. But why specifically this individual? And why, after I have submitted for a previous year, if it was at the beginning, I have not served for a single day, not even one single day out of 365 days. So, Lordship, if I have not served for one single day, how can he, by an arbitrary and illegal order, be made as my reporting officer? And that too, retrospect. And this is being done after I filed the case. Series and sequence of arbitrary and action against me. And they have returned the report. The action has been completed from my side.
How many years have you completed?
Lordship, I
That post?
in January 23. the respondent in the present. At a place called Gauhati. Have not reserved one day. I've not reported one day of it. I have submitted on time. And now they are doing a post facto.
What is that? They say it is a case of exigency of service.
Lordship, there is no exigency of service. I'll bring that. Lordship, basically, they have told a lie and they are telling 10 lies to cover it. And why I say that? I'll go to paragraph 3 at page 5 of my I. Now, when we read it,
Referring to
I'm referring to my IA. Paragraph 3. That the respondents had filed an affidavit in opposition inter alia and repeatedly, stating that the transfer of the petitioner was necessitated primarily on the ground that two fixed tenure contractual employees, law executives of 2022 batch, one, and I quote, posted at the Corporate Law and Arbitration Department, Rishikesh, and the other at Tehri Project, which is 70 kilometers away from Rishikesh, and their contracts are set to expire in April 2026. Thereby, they created an administrative exigence. And Lordship, this they have not said it once. In their affidavit, they have said it twice. Lordship, sorry, they have said it twice. I'll draw your attention.
so what is wrong with this?
Lordship, I'm coming to it. What is wrong with it is that it is not April 26, it is April 27. Lordship, if I may be permitted, and if I draw your attention to page 11 of the same IA, at annexure 1. Instead of 4 years, shall read as 5 years. So, Lordship, I come to para 11 at page 81 of my board. Last line, Lordship. Last line. And their contracts are set to expire in April 2026. I also draw your attention to para 13 at page 82. The 6th line, para 13, contracts again. That the deponent states that out of the 13 legal executives were recruited during 2022-23, only 5 are presently working in the company. In fact, this itself raises serious doubts, Lordship. In 2 years, might have 8 out of 13 executives left.
that raises itself the question. And I continue, Lordship, are presently working in the respondent number 1 company, and 2 of their contracts are set to expire in April 2026. This is a false statement. And this is an attempt to mislead the court. I'll again draw your attention, and this has been repeated at para 31C of page 98. Lordship, para C, I am reading the third line, this thing. Non-joining of the petitioner would further exacerbate the crisis in as much as the contract of another law officer engaged on fixed term basis is expiring in April. Again, repeatedly, lying on affidavit, Lordship. If a respondent company can lie on affidavit before this honorable court, my condition now is that as a young girl of 28, the whole company has got after me. And for no fault of mine, just because I have approached the honorable court. Therefore, Lordship, what I think that this stand taken by the respondents in its affidavit is factually incorrect, misleading, and contrary to official records. Now, why I am saying it?
This particular official record of extension for does it have an effect on the contracts of the persons concerned?
So they joined the same batch in 2022. So 22, 4 years becomes 26, Lordship.
But is it applicable to these persons? Or
Yes,
is
it is
for
applicable.
somebody else?
Yes, it is
Or
applicable
is
to
there a
them.
separate contract?
No, Lordship, it is applicable to them. Yes, I'll specifically read that out, Lordship.
Your ground for challenge is essentially that clause 6 has not been followed.
It's not been followed.
And there is no administrative execution.
There is no administrative execution. And Lordship, they are giving a false affidavit. That's the main thing is, and it is not only that, Lordship, I will now, from the beginning, they're attempting to cover up. Why I state that? This is an attempt to cover up. Lordship, I will, why I state that?
Doctor, what is the ground for objection here?
Lord, for the court of law, some decency should be maintained. End upon saying that we have made a false statement.
Examine that.
Your Lordship, kindly say why it is. Your Lordship, kindly say this affidavit was filed on 2nd March 2026. By your policy decision, the term was extended from 5 years to 6 years. How we have, my Lord, making some false statement here? The language should be amended, not in this manner. We haven't heard it making such.
When was it extended?
Your Lordship, kindly see page 11 of this IE. Your Lordship will find at page 11 the order dated 10/3/2026.
10/3/26.
Yes. Now, corporate teacher circular dated so and so. Modification in the scope of engagement of personnel on fixed tenure, purely short-term basis. Now, here your Lordship will find number 1. Whenever the period 4 years,
it will be read as 5 years.
Yes. Now, this has come on 10/3. We filed our affidavit on 2nd March. Now, repeatedly saying that we have made a false statement, we want to confuse. We make such a submission.
Right, but to stop this communication.
No, but it's there. I'm not saying that it has not been. But then, is the submission kindly, you
Now,
kindly see.
His ground for challenge in the transfer is that this is not
And my lord, I
subject to correction. As far as I recollect, your position was that of extending this tenure prescribed.
and that is our stand, my lord, and I will satisfy lordship in every bit. Let him finish, I will satisfy.
Let us continue Monday or Tuesday. You don't have to put it on. We have already filed it. We have to pass an order. What do you want to put it on record? What have you not filed?
What I just told to you.
Yeah,
Fine.
without filing, how will you come before the court?
That I will find. We are talking about the fresh order, fresh order regarding my reporting center.
That is a separate issue.
That
You
is
will file,
also,
you don't need liberty.
that is
That's
also
got nothing to do with transfer.
part of
Up to you. Want to file, you don't want to file, but it's got nothing to do with transfer. You're essentially challenging the transfer order.
absolutely not that is, but we permitted to.
Any permission is a separate.
Lots
of action. Mr. Dotto is Monday, all right?
Monday, my lord,
Then 12,
can you lordship take on 14th?
14, all right, 14.
Lordship,
You have to order organize your calendar as per courts. 14th. You require some hearing, so you're putting it on a Tuesday or you have it on 19th. 19th. Readings are exchanged.
I'll take just half an hour.
much nice.
You may take half an hour, I may take an hour to understand.
I was lawyer saying half an hour.
I never.
So like,
Much obliged. But the food will be around. Can you or can you reply and tell him what are they continue.
I rejoined her.
Reply to the affidavit. Tell him what are they continue.
After weeks.